Hello everyone and welcome to today's webinar. I think we're up and running now. My name is Laura Murphy. I'm HR Manager with Bright Contracts. And also here today is my colleague Michelle Arkins, who's just beside your screen at the moment, but Michelle is going to be speaking later on today as well. So just to get going here, bear with me. So I'm really genuinely delighted to be giving this webinar today. It's a great opportunity for me to demonstrate to you the unique solution that we now have in place with IPU and bringing it to the members. Very briefly, Bright Contracts is a software product that allows employers to create and manage their own contracts of employment without the need for having to use expensive legal assistance or HR consultants. And users also of the software have access to a range of support, HR support, including online support and our employment advice helpline. So we really made it as a one-stop shop for your HR needs, and we have designed it for and with SMEs in mind. So in partnership with the IPU, we have now created an IPU-specific version of Bright Contracts. So this means that for you as IPU members, you now have access to employment policies, procedures and job descriptions that are specific to the pharmacy business and that are recommended by the IPU. So after, I suppose, just giving you again a little bit of background into it, I suppose after several months of working behind the scenes, we released this product in February, 1st of February, just gone. So I have to say the take-up so far has really been great. The initial interest has been positive, and we've really kind of exceeded our expectations so far, and feedback that we've got has really been quite positive as well. So just to give you a little bit of background into Bright Contracts before I go on any more, the Bright Contracts product is created and supported by Source Software, and Source Software provides a range of software solutions to SMEs, and we have over 80,000 customers across Ireland and the UK. You may be familiar with probably our most well-known project is product Source Payroll Manager. So Bright Contracts was launched then in 2012 as a result of increasing queries, I suppose, that we were receiving on our payroll helpline around the area of employment law, as our customers, primarily who were small employers, tried to get to grips with, I suppose, ever-changing and ever-developing minefield that is employment law. So when Source Payroll Manager launched over 20 years ago, at the time that really revolutionised computerised payroll. And today, now 20 years on, we see that Bright Contracts is probably doing something similar for the creation and management of contracts of employment. We're 4 years in now, having launched in 2012, and we have built up a really strong reputation, and we really are the go-to solution for many Irish SMEs. But in terms of the relationship, I suppose, and where the IPU relationship came out, it probably was one of our earliest relationships with Sean McHugh, who has been an employment advisor for the IPU for many years. Sean is a director of Bright Contracts and has been heavily involved in making Bright Contracts what it is today. I very kindly put in a picture of Sean there, and I'm sure he's going to be delighted, but maybe it might ring some bells with you. You might remember who Sean is. So Sean's our director, and said he's heavily involved with us as well. So that's just a little bit of an overview for you of what we are and who we are. But I do want to crack on, because today is the main point of today's webinar, I suppose, is kind of to fulfill our purpose to help you as pharmacists to keep on top of ever-changing employment law. I'm going to take you through some key employment considerations, particularly around the areas of contract of employment, and then I'm going to pass you over to Michelle, who will demonstrate the tailored Bright Contracts IPU solution to you. We'll also have a question and answer session at the end, and I would encourage you to please ask away with your questions, whether they're related to the topic today or not, because we often find that some of our most informative webinars come when we get to the Q&A session. So I hope you do find the webinar useful and informative. So first, I want to give you a brief update on some of the recent changes in employment law legislation. And the issue with employment law is that it is ever-changing, and keeping on top of those changes is a real challenge for small employers. So 2015 saw some of the most radical changes, I suppose, in the area of employment that we've seen for over 70 years in this country. And we have, again, more changes set for 2016. The first and the most major change was the Workplace Relations Act, which came in October 2015. And with that, we brought in brought in the new WRC. So up until October, we had a very disjointed structure for managing employment complaints and compliance with employment law. We had all sorts of different bodies. We had NERA, we had the Labour Court, we had the EAT, and they all sat independently, and they kind of overlapped in their structure and decisions, and often if an employee wanted to take a case, they had to go to a number of different bodies. So the whole system had kind of evolved as a reaction to legislation changes over the years, so that it was quite disjointed, so change really was needed. And so the WRC has come along, and it's taken over the functions, I suppose, of all those other bodies that we used to have, and we now have one body that takes care of all employment compliance situations. And you're probably familiar now, you've probably seen the WRC logo in the news every night, with the Lewis strike talks that are going on. So it's a massive change for employment law. We've also had a new minimum wage which came in January. So now minimum wage is $9.15 for most adult workers. I suppose the key point to say here is that with this minimum wage, we also now have a new low pay commission. This is the first time that we've had a commission set up to review minimum wage. And their responsibility will be that on an annual basis they will review wage rates across the country, and they'll advise the government on wage rates. It's not to say that we'll have a new minimum wage every year, but they will definitely be reviewed every year. Another change which can be quite confusing, I suppose, but is that from 1st of August last, employees can now accrue annual leave whilst on sick leave, and that's certified sick leave. So generally you're talking about people who are on long-term sick leave. The legislation is effective from August 1st, 2015. So if you had somebody who was on sick leave, long-term sick leave prior to that they won't accrue sick leave for that period, but they will accrue sick leave they will accrue annual leave for any periods of sick leave from 1st of August. I'll just touch back on that in a few more minutes, just to give you a little example of it, because it can be quite complicated. It's just so you're aware of it. If it's a situation in your workplace, I would suggest that you maybe get advice on it, and I'd certainly be open to taking some questions on it as well later on. Finally then, paternity leave. This is a new piece of legislation. It's again due to come in September 2016, where we will now, it will be legislated for the first time that we have paternity leave in this country. So in terms of this very much brings us up I suppose in line, or even not even in line, but brings us up with our European neighbours who would have paternity leave legislation. So the plan is that it'll be for 2 weeks, and it'll very much be paid similar to how maternity leave is paid at the moment on a weekly amount from the government. So there's no onus on the employer to pay anything, but definitely there's an onus, I think, on employers to review policies and procedures just to ensure that they're up to date and that everybody knows what's applicable and what applies to them. I just have one slide here on the sub-minimum wage rates. Again, as I said, the new minimum wage rate applies to most adult workers, but obviously then if you have younger people who are under 18, there's different wage rates for them. I'm not going to go through them all now. These slides will be made available to all of you afterwards, so it's just of interest to you if it does apply to you. I've included those figures there. Just a couple of very quick examples when we talked about the accrual of annual leave whilst on sick leave, hopefully to clarify the issue for you a little bit more. As I said, it can be quite confusing. But if I have an employee A who was certified sick from the 1st of November 2015 to the 31st of December, so that's 2 months, which was in the limit after the 1st of August when this legislation came in. So they will accrue annual leave for these 2 months that they're out. They have 15 months after the end of the holiday year in which to take that. So for this individual, they will have up to March 2017 in which to take the holiday they accrued in November and December 2015. The next one, if an employee was certified from the 1st of June 2015 to the 31st of December 2015, this employee was out sick before the legislation came in August. So from the 1st of June to the 31st of July, they won't accrue any annual leave for that period because the legislation wasn't in. They'll only start accruing annual leave from the 1st of August. And again, they can take that up until March 2017. So then the final one is if I have somebody on sick leave from 1st of January 2016 to the 31st of December 2017, so for a period of 2 years. So they will accrue annual leave for that whole 2-year period. And again, it's 15 years after the end of the holiday, 15 months, apologies, after the end of the holiday year in which they can take it. So it will almost be broken down into 2 separate allocations. The 2016 holidays can be taken up until March 2018, and the 2017 holidays, they'll have them available to them up until March 2019. And there's no onus on employers to pay for this annual leave, it's just the employee is entitled to take it. So that just is a little bit around that. Again, I'm happy to take questions on that if you have any. So I want to move on now to talk about contracts of employment, and I really cannot overemphasize how important the contract of employment is. It really is the foundation or the backbone of your employee-employer relationship. And in terms of that employee-employer relationship, your contract of employment really is the most important thing that you'll ever deal with. We did some research a while ago, and we came up with this 60%, and you're probably wondering, well, what is this 60%? 60% of the people that we surveyed at the time, the employers that we surveyed at the time, did not have contracts of employment in place. Now, coming from an employment law background myself, HR background, I find this incredibly high, as it's a legal requirement that all employees should have written terms and conditions in place. So it's mind-boggling to me that it would be so high, the percentage of employees that don't have written terms in place. But even even from your own point of view as employers, I think it is also quite shocking when you consider the consequences that employers are leaving themselves open to by not having contracts of employment in place. And we'll just go through them now. So firstly is the cost of non-compliance. If you are found not to have contracts of employment in place for your staff, you will face a fine of 4 weeks' pay per employee. So if I'm a small pharmacy and I have perhaps 6 staff with an average weekly wage of €450, I could be facing fines of up to over €10,000. So in my experience dealing with small businesses, I don't really think that's a figure that many small businesses would be able to easily swallow without having serious impact on their own business. In addition to the actual cost, there's further additional protection that having a contract of employment can offer. Not only having clear documentation, not having documentation can leave you open as an employer. And I just wanted to give you an example of this. So an agreement between an employer and an employee is usually made up of 2 different types of terms. Your express terms, so i.e. those that are down in writing, and they are generally agreed upon by both parties, and your implied terms, which are usually unwritten and tend to have developed over time. Your implied terms can be as a result of kind of a piece of legislation, so minimum wage. It's implied that everybody will at least receive minimum wage. But an implied term can also be something that has developed over time as a custom and practice. The issue with custom and practice is that it's never actually agreed between both parties, and it can often and quite easily lead to disagreement between both parties as to what actually is involved in the term. And I suppose just to give you an example of this, there was a case, I suppose, in the downturn when there was a printing company, and every year they had paid their employees a bonus. And then with the downturn, they found that they could no longer afford to pay the bonus to their employees, so they decided to, on this particular year, withhold the bonus. The employees in question took the employer to court, claiming that it was custom and practice and that they were entitled to the bonus. And the judge at the time found in favour of the employees that yes, it was custom and practice and that it would have been fair and unreasonable not to pay the bonus. And so the employer, although they felt they couldn't afford it, they had to pay the bonus. And that's a really good example of if they had had a very simple clause in their contract of employment, something simple as much to say that bonuses are paid at the discretion of management and they'll be decided on a year-on-year-off basis, that would have been pretty much likely enough to defend the employer in that case, that simple clause in the contract of employment. But without that, it was a custom and practice, and they had to pay that. So I suppose that leads us on to who gets a contract of employment, and sometimes it's something that I come across quite a lot. I suppose when employers would say to me that they have 2 or 3 full-time employees and they all have contracts of employment, and that's perfect, they're sorted. And then I would say to them, do you have any other employees? And they say, no, we'd only have Mary and Johnny who come in at the weekends, and they do a couple of hours for us here and there, but it's not that much. And the thing is, there seems to be this myth that once you are not a full-time employee, you don't need a contract of employment, which simply really isn't true. Anybody basically who's on your wage bill should have a contract of employment. So your full-time workers, yes, absolutely, they should have one. But your part-time workers, if you have somebody coming into the shop on a Saturday or a couple of evenings a week after college, something like that, they're going to need a contract of employment as well. And your seasonal workers, if you have somebody coming in over Christmas, if it's a busier period, something like that, your seasonal workers, they'll need contracts of employment. Your temporary workers, if you have somebody coming in for a fixed term contract for a fixed term period or for a specific purpose, for example, you're not quite sure when the end date would be, but it's the purpose of perhaps it's to cover maternity leave or something like that, they'll have to have a contract of employment in place. And your casual workers, so the person you call when perhaps your busier periods, you can't guarantee work for them all the time, but they're kind of the as and when person that you call, and it's very important to have contracts in place for them. Now I say that because usually in most industries, the casual workers quite easily, I don't say easily defined, but obviously there's an exception for yourselves as pharmacists when we're talking about locums, and it's slightly different, I suppose. Legislation would apply to a locums, and there can be different arrangements. Obviously, the locum may have their own limited company set up, in which case they wouldn't be an employee, or they'd be coming from an agency. So in terms of your locum and what type of contract they would need or require would very much depend on a case-by-case basis, I suppose. But for the most part, when we're talking about who needs a contract of employment, again, if it's anybody who you're paying wages to, they're on your payroll, no matter how few or how many hours they do, they should have a contract of employment in place. So that brings us on to what actually is in the contract of employment and what should be included in it. And the Terms of Employment Act specifies certain information that must be included in your contract. So it's not something that you just kind of make up or put in together. It's actually stated in law what needs to be in your contract. So I've put it out there for you, and also the name, address, place of work, job description, duration. If it's a fixed term contract, you want to say when the contract is going to end or expire. Their hours of work, including overtime, this has to be included as well, or if there is any overtime to be paid. Their rate and calculation of pay, reference to statement of the minimum wage, paid leave such as your holidays, any pay with regard to sick pay, and pension details, and notice of termination. So they're all statutory requirements that you have to have in a contract. And I know Michelle shows you the software in a little minute, and she'll go through that as well with you. But in addition to the statutory clauses, I always recommend some additional clauses that can really clarify the employer relationship and offer you greater protection as an employer. So just to go through them now, exactly what clauses you will put in your contracts, I suppose, will really depend on the individual that you're hiring and the particular person and their seniority, I suppose. But I've given an example here for you. Probation is a key clause that we would advise as an additional clause. It very much helps you manage your new employees and to try and find out if they're right for you and if you're right for them. A pay in lieu of notice clause is a useful clause, particularly when you're coming to the end of an employment agreement or relationship. Can help you kind of terminate them a little bit quicker. Bonus, and we've already seen the example of the bonus, that why you might need a bonus clause. Confidentiality, again, I'd say this would be a key one for yourselves. So you obviously have, if you have key staff who are dealing with client confidential information across the counter, you don't want them to be disclosing that in public places. So a confidentiality clause, a well-worded one, would be really highly recommended for yourself. A time and attendance clause. This is a useful clause, I think, to have, because it's such a small issue, or from the outset, such a small issue of somebody coming in late and leaving early can really escalate and can cause issues. So if you have a clause that helps you manage that situation, it's really going to be to your benefit, really. Post-termination restrictions, which I'll just come back to briefly because I think it's an important clause for yourselves, and then reference to company rules and norms, which could be reference to your company handbook. So you want to keep your contract, the main aim of your contract is you want to keep it, I suppose, tight, and you want to keep it as concise. You want to have what you need in it, but you don't want it to be overly lengthy either. So there are going to be additional policies and clauses that you want to be able to refer your employees to. So that will be a good point of reference to have in your contract of employment. So I wanted to touch on post-termination restrictions, because there's several examples and several cases of the use of post-termination restrictions in the pharmacy industry, and you may also be familiar with the term restrictive covenant. It can also be referred as that. So the post-termination restriction is typically a clause included in a contract of employment which prohibits an employee from competing with their ex-employer for a certain period of time after they have left the business, or prevents the ex-employee from soliciting or dealing with customers of the business by using knowledge that they gained whilst they were working for you. A key point with your restrictive covenant is that even if you have a signed agreement and it was signed as part of the contract of employment, that does not necessarily mean that it is enforceable and that it is binding. Because enforcing a restrictive covenant clause is really it's a severe encroachment on an individual's freedom to do business and to make money and to make a living, really. And so for that reason, courts will only enforce clauses that are aimed at protecting them. There's kind of two main criteria the courts will look at, I suppose. They'll allow clauses that are really aimed at protecting the legitimate business aims or the business interests of a company, and that go no further than what is reasonably necessary to protect those courts. So in the event of a clause being challenged, it really will be, the responsibility will be on the employer to show that it was justified, the clause was justified and was sufficiently narrow. So it's difficult for me to say what is acceptable, I suppose, for a clause, because it'll very much be dependent on a case-by-case basis. You probably are familiar with a case in 2014 that was brought to the courts of a pharmacist who had left the pharmacy, and he brought a case against a restrictive covenant clause that he had signed in his contract of employment. And the court actually found they refused to enforce the clause because they found that the legitimate business reason wasn't sufficient. The pharmacists at the time were claiming that it was this employee was a key member of staff, and it was a detriment to their business by him leaving it, and the court were able to find that actually wasn't the case, because this employee wasn't actually, for the most part, customer facing, and they were behind the scenes. So they lost it on that situation, but they're also looking into that case further. The restrictive covenant in that case, or in that clause, stated that the employee wasn't allowed work for a competitor for a period of 2 years after he left employment. She, should I say. I think the court or the judge at the time never actually got to look at that part of the agreement that they had found against it before then. But I think it's fair to say that they probably would have agreed that 2 years was not reasonable and was quite excessive. Can you prohibit somebody from working and making a living for 2 years is the question, and that is generally probably going to be viewed as unreasonable. So that's what I'm talking about when I'm saying that the restrictive covenant needs to be sufficiently narrow and it has to be reasonable. So what I'd say to you is, I'd say definitely if you've got some key members of staff, put a restrictive covenant in place if you think you need to, but just really be careful when you're writing it and get maybe some advice, and also regularly review it because as that person's role changes, the restrictive covenants might need to be changed as well. But it is something that is important. We have included a sample clause, or started maybe some sample wording, I suppose, to get you started, and Michelle will talk about that in a little bit more detail later on as well. So just a few misconceptions that when we started talking to our customers, again, most of whom are small employers, we soon learned there was a lot of confusion amongst Irish employers when it came to contracts of employment. I've listed some of these kind of misconceptions and queries and questions that we came across here for you. So whilst the importance of contracts can't be stressed enough, they really shouldn't be something that employers fear or feel aren't necessary for them. So just to address, I suppose, some of the misconceptions, it really doesn't matter how few employees that you have, whether it's 1, 2, 2,000, you need to put contracts of employment in place because the same employment law applies to all employers. And also it doesn't matter how long your employees have been with you, it's never too late to implement your contracts of employment. And again, we have the helpline, and we see it time and time again on our helpline when an issue arises with an employee, and then you're kind of firefighting if you don't have documents and procedures and policies in place. So we would suggest to people, get your policies and procedures in place early before issues do arise. And again, people say to us, oh, employees will think we're bringing in rules or trying to be untrustworthy or whatever it is. There's just kind of a lack of trust, perhaps, perception that there'll be a lack of trust. In my experience, this really isn't the case. It's supposed that the key point is really how you implement your contracts and how you go about that. And again, that's something that we can assist with as well if you were looking to do that. Just to provide some stats for you as well on contracts, and there's a mindset again amongst employers that really when we talk about these fines or these cases, well, they're never going to happen to me. I'm only a small employer, that's not going to happen to me. But it can, and it does, and it has. And in terms of compliance checks, both planned and unplanned workplace inspections are carried out on Irish businesses. Previously, these were conducted by NERA. Some of you may or may not be familiar with NERA. I'm not sure, some of you may have had an inspection, but NERA now falls under the WRC, the Workplace Relations Commission that we spoke about earlier. And inspections are carried out by workplace inspectors. And these workplace inspectors actually now have increased powers that NERA had, and they actually have the ability to issue on-the-spot fines of up to €2,000. So looking at the stats then that I have here, in 2014, NERA as it was then, carried out almost 6,000 workplace inspections, both random and planned. I've included the graph there showing you the industries, and I think it's clear to see that the food and drink industry is obviously a key area of focus for inspectors, and many prosecutions have been made against employers in this industry. But you can also see that the retail sector is the second most highly inspected sector there, so it's interesting to note that. So I suppose looking at this graph as employers in the retail sector, if you don't have contracts of employment in place, or if you have any doubts in relation to your existing contracts of employment, it really shouldn't be something that you're thinking about putting on the long finger, I suppose. So I want to move on to talk about policies and procedures now, because it's kind of the second part of the service as well. So your policies and procedures are descriptions of how all employees, regardless of their job description or title, are expected to conduct themselves. And employee policies and procedures are typically contained within an employee or company handbook, staff handbook. The titles, I suppose, are often interused. But having a handbook in place really gives you an opportunity to set out in detail what you expect from your staff. You're probably wondering, I suppose, why I put this crazy picture in here, but I came across it, and I suppose the line is that good fences make good neighbours, and I think this kind of sums up that good boundaries and clarity between two parties really leave less room for disputes or rows, and the exact same applies when we're talking about the employee-employer relationship. Now make no mistake about it, the contract of employment really is the most important document that there is when we talk about the employment relationship. But having a staff handbook or an employee handbook in place really can also be incredibly useful, especially to communicate some essential policies and procedures that you have within your organisation. In terms of what should be in your staff handbook, I've broken them down into 3 different sections: your legally compulsory, your highly recommended, and the recommended ones. To look at the legally compulsory one is your disciplinary procedure, and this is really, really important. If I kind of say, if you take one thing away from today, again, this is kind of would be one of the key points. So in order for an employer to dismiss an employee, even in instances of gross misconduct, where you think it's incredibly serious, you are expected to have a clear and documented procedure in place and to have followed it. And again, this procedure is usually included as part of your disciplinary procedure, which is normally, again, contained in your employee handbook. And this is a legal requirement. So there's a legal obligation on all employers to supply all employees no later than 28 days after they start employment, with a written procedure that the employer will follow when dismissing an employee. And again, this is really important. So what your disciplinary procedure is going to kind of set out is the procedure that you will follow in order to dismiss somebody. So regardless, as we said, how serious you think the issue might have been, you have to follow the procedure. And there's several cases on this, and I kind of was looking to see if I could find a case that was kind of relevant to yourselves and pharmacists. And there was a case, again, back in 2014, where there was a pharmacy worker, and she was found to be taking money out of the till and to be replacing it with IOUs, that she would repay the till in a day or two, or whatever the time frame would be. So this came to light, or came to the attention of management. She was suspended pending the investigation, which was fine. She was then written to attend an investigatory meeting, but she wasn't notified of why or what the details were, and at that meeting she was dismissed. So the judge found that, yes, whilst this individual had, the judge found in favour of the employee, firstly. So you think, although she had, been taking money out of the till, the employer had dismissed her, which, you might think from the outset that that's fairly a valid reason why you might dismiss somebody, but because they hadn't followed the correct procedures in dismissing her, the employer lost, and she was awarded €4,000 as a compensation. So it just highlights to you that if you're going to dismiss somebody, and in my experience, dismissal is such a huge issue. Like, it comes up on our helpline time and time again when you have somebody who's just perhaps not toeing the line, or there's performance issues, whatever the case may be. It is an issue for employers, and it does come up. It mightn't be today or tomorrow, but it could be in the future. So the best thing really is to have a disciplinary procedure, and it will act for you as a guide when the case happens. And it'll be very important that you follow that procedure. There was another case of a truck driver, again, just to show you how, it seems so apparent and so obvious why you might dismiss somebody, but then when it happened, it wasn't. So the truck driver was turning up to work under the influence of alcohol, and he was dismissed again, and it was found that the dismissal was unfair because, again, correct procedures hadn't been followed. So this disciplinary procedure, can't overemphasize how important that is for you. Just very briefly, because I'm conscious of the time, I know I want to show you the software as well. A grievance procedure is really important. The grievance procedure gives somebody a platform or forum of where to raise issues if they have an issue with their employer. And it'll be key. And it'll be key as an employer in defending a case, if you ever have a case brought against you, to show that you went through full grievance procedures and you followed the process. It will very much act in your favour. I've also included other highly recommended policies in terms of an equality policy and a bullying and harassment policy. Now, as I say, these are not legally compliant or legally necessary policies. There are codes of practice on these policies. So the WRC and the predecessing bodies before the WRC have issued codes of practice on these equality and bullying and harassment. So that just kind of illustrates the importance that they place on having these policies in place. And in terms of ever getting to a tribunal, these are really going to help you and assist you. I've listed some recommended policies, but I don't want to dwell on them too much because this is probably, I suppose, key where we've been able to work with the IPU in developing policies and creating policies that are really specific to you and your organisation as pharmacists, and Michelle is going to highlight them to you now as well. So I suppose that leads me on nicely to pass you over to Michelle to demonstrate the software to you.
That's great. Thanks very much, Laura. Now, just get you set up here. Now, what I have open in front of me is just a mock company that I set up earlier on. So I just kind of called it Arkins Pharmacy Limited, just to give you a bit of an overview of what exactly, when you download Bright Contracts and just enter in your details of your company, what you'll face first off. It starts off, if you look in the middle of the screen at the top, with a summary, an employer tab, a handbook, and an employees and contracts tab. So we'll go through one of them kind of individually, and I'll just give you a quick overview of each section. I know Laura has probably covered the basis of a lot that we're going to talk about today, with the importance of obviously issuing all your employees with contracts, and then the need for good and sound policies and procedures in the workplace. So if we look here, we have 12 employees in total in our pharmacy. At the moment you see nothing but red flags, so we know there's an awful lot of work that kind of needs to be done here, but again, the beauty of the software, it'll allow us to do it very, very quickly. So we have the employees, and what's being flagged to us at the moment is that we have the 12 without a handbook and without a signed contract. So we'll deal with that first off. The second tab then to the right is an area where you can go in and you can download just, well, really uploading just from your documents or your pictures, maybe your company logo, and then that'll sit at the front of both your handbook and your contracts. And then in here will be your registered employer name, trade name and address. And again, that's very important when it comes to your employment contracts, that you have the correct address for the employer. The third main tab is our handbook tab. I'll run through a lot of that with you in a few minutes as well, and I'll outline just a few areas that have been developed further for pharmacies. And then we'll go into the employees and the contracts. And if we look inside the screen here, I have a couple of the employees that are set up at the moment. I have two, Bernie and Brian, and I just started off basically doing up a bit of a contract for them. But just so you can see actually how fast it is to create a contract, if we look at Bernie here, this is just the employee details are at the very front. Now it's very easy up here on the top left to be able to import data through either your own payroll, or you can take a CSV file. So export out of your payroll into a CSV file, and then you're able to import your employees literally within less than a minute. So then all you have to do is to give them a new contract. So when we look at Bernie's contract here, again the same thing applies. All you're doing is following a series of tabs across the top of your screen. And what you're doing essentially is building the contract. And exactly what was mentioned earlier, when you look at kind of what you need to put in, there's normally about 16 main key areas that as an employer you must set out for your employee, and just to define those terms. And we'll give you kind of the outset. Again, it's only filling in the blanks, putting information in at all stages, and you'll have a look on the right hand side if there's any, or for whatever reason you might have as to why this content is relevant. You just click on the little information snippet tab there, and then that'll kind of outline why we've included it and why it's important. So we have the name and address, obviously, of the employee. It's female, or sorry, she's female, her date of birth, the job title, which is the pharmacy technician, and then we've included just in the job description text box that obviously that the job description itself is a separate document to be read and signed at a later stage. And you'll see down here on the left hand side where we have the IPU logo. If you click just into that area there, you'll be able to have full job descriptions done for most, if not all, of the positions in your company. So they're very, very handy just to use as well, and just have signed off on. We have a rate of pay here, and then we can click down on the little arrows if anything else is changed. So we have €20 per hour, we pay monthly, and we'll actually be paying by credit transfer. That's perfect, and we just press save, and then you just move into the next tab. The date of the contract will leave us today, the 15th of March, and then obviously we'll be including in here the date of commencement. And obviously this is extremely important that it's accurate, sorry, apologies, as if for reasons for redundancy, we need to ensure that the correct date, so we'll just even put in when she joined the company, it was back in 2013. It's perfect. If she came from a different company, again, you have a little area here for the commencement of continuous employment. And again, if you're a little bit unsure, click that and that'll tell you when we'll use that. The probationary period length would be 6 months, and that would be the norm in most companies. And you'd include by ticking the box here, but putting the probationary period in. Now, for this lady, for Bernie, we won't need to do that at this stage, because obviously she's with us since 2013, so we're happy enough that she's kind of passed all the probation. We have a little area here where we'll tick boxes underneath our place of work, where if Bernie's required to drive, if she's expected to work elsewhere, perhaps we have, 3 or 4 different pharmacies all located in the Leinster, Munster region, or whatever it is, and there could be times of staff shortages, holidays, where we might need to pull from, one shop to the other. So in that case, we tick that box, and that would allow us to have that element of flexibility again in the company. And then what it does, anytime you tick any of these boxes, it'll just pull the content into the contract that kind of sits behind in the software for you. So again, remember, all you're doing is literally just building as you go along. The contract type here for Bernie will be permanent, but as Laura touched on earlier on, you'll have, a lot of different ones. You could have temporary, specific purpose, fixed term, indefinite duration, casual. And again, you'll get an outline of, when you would use each contract and when it might be applicable. Working schedule here is normal hours, again, but we can still pull in for shift work or casual hours. And Bernie will be working 37.5 hours from 9 to 5:30. Again, you can amend and change all of that. You can also change when they work. So let's say Bernie works from Tuesday to Saturday. And then we can enter in the text box here anything that might be relevant, where there could be exceptions outside the normal hours. So for example, you may be required to work additional hours in cases of staff shortages, annual leave, festive, busy periods, where you might also be able to or have to work, late evening shifts or weekends. So again, you just build in a few different things there to give you a little bit extra flexibility. And we have a text box for, details of the collective agreements. So even with the EROs, I know with the security industry and domestic cleaning, we can build them in, and Bright Contracts is set up for all of that. But in your situation, you don't have to worry about that. We go into overtime, holidays, other pay. Again, we set out whether we pay for overtime or not, and if we do, we can just put in the text box here what the details of the overtime, or perhaps if they get any commission or bonuses or anything else that might be relevant, health insurance or whatever little kind of perks and bonuses throughout the year, we can enter it all in there. If there was accommodation provided as part of the employment, we would enter into the text box below it. And then we have the area for our annual leave days. Now, Bernie's with us a long time and works full-time, so she'll be entitled to the maximum 4 working weeks. So we'll leave in the 20 days there. But if you have somebody that's part-time or short-time, you'll just default that there to 0. And again, the contract will show that once you're ready for print. Annual leave, we'll leave it from the 1st of January to the 31st of December, so that's fine. And then we've included a little text box here where the employee may be paid in lieu of notice in the event of termination. So that just means if we were terminating Bernie's contract of employment and she had to work out 2 or 3 weeks notice, we can pay her in lieu of notice. So she can leave and we'll pay her a wage as normal. But to remember that the end date is, the 3 weeks following that. And then whether we have a sick pay arrangement and what they are, and perhaps it'll be set out in the company handbook depending on the company. So you just have a little area that you can include that. So just press save. Move into miscellaneous. The rest breaks in this shop anyway are unpaid, and we'll give the 16 minutes. So again, depending on the hours worked, after 4.5 hours they're entitled to 15 minutes, and after 6 hours entitled to 30, which may include the first break. So you can just have a little outline. If somebody's working, depending on the hours, you can enter in the text box what kind of breaks they'll receive and the length of the breaks each day. And we also have an area where you can talk about the compensatory break details. So if there ever was situations that somebody couldn't get a break on a day, that they would obviously notify the manager and then it'd be given at a later stage, or that you literally be paying back that rest period. We have the notice that's required for termination of employment by the employee. So in this instance, we'd like a month. You can have a week, 2 weeks, 3 weeks, entirely up to yourself what you want to put in. And then we have an area here with the text box with the statutory notice. So we know anyway with the law, obviously under the minimum terms of notice, what anyone has to give, and that'll be basically dealt on the length of service that you have in the company. But there is other times where we may request or want to give a little bit more, a little bit extra to that. So if we were to say here that the employee, we would like a month's notice from the employee if they wish to leave us. It's best practice then obviously to give the month back if we were terminating their contract with us. So we've just included that area there. And then we walk down to if there's sick days, how many days, are we happy enough for the employee to be out before we'd be looking for a doctor's certificate. So again, the norm is about 2, but it's up to yourself, whatever you want to work out or include in your own contracts. And then also if the notice that you'd like to receive if they won't be able to attend on any particular working day. I know we'd all love as much notice as possible, but I suppose we have to be practical at the best of times, so we'll even just include maybe 3 hours. In the text box below, we've left an area where you can kind of enter in the details of the way that your company deals with an employee that's out, absent. And the reason we say this is that we obviously don't or would not accept or want text messages or Facebook messages or getting notifications through LinkedIn. Really what we want is the employee to ensure that they contact their immediate manager by phone, and obviously that we can get a bit of an idea why they're out and the length of time that we think they'll be out for as well. So you can just enter in your details there. The retirement age, we have 65. We'll just put it up to 66 because that's now, if we were to go with just in line with the pensions and that, but I know it's due to rise again. I think by 2020 it'll be up at nearly, I think retirement age is 68. We also have then the pension scheme. So if we have one in place, that's great. Again, tick the box and you can enter in the details and the contribution maybe that the company pays. But in this case, we don't have a pension scheme in place, so we need to have the PRSA provider. So I have a PRSA provider with my own local bank. So I put in for AIB Bank, and all you need to have is just the documentation on site that's accessible to all the employees, so they can come up and have a look at it, see if they wish to join it, and then as the employer, all you have to do is ensure that you make the relevant deductions through their payroll. You don't have to pay into it or anything like that. But as I say, if you don't have one, you need the other. Then we have at the very last tab then, we have a section here which Laura kind of spoke about earlier on, where we can include sample additional documentation. Now, the reason for this as well is obviously it secures the employer, by putting up, certain kind of parameters and additional, I suppose, protection. But it also would mean that you can create and build a contract for somebody that's very senior in the organisation, and then again somebody that may be required to work perhaps only 4 or 6 hours at a weekend to cover an evening shift. So you can see where someone's terms and conditions might be different to the others, and that's the flexibility that Bright Contracts gives you. Is that even though it's simple to create it, you still have a lot of leeway at the very throughout the process as well, to be able to amend and put in the extra clauses. So just with Bernie, what we've included is the section on garden leave. We've also the acceptance of gifts, so obviously to ensure that we've put a kind of a value on them if there was somebody that was to come in. You see this a lot, I suppose, probably the kind of nursing homes and areas like that, and in sales and suppliers in hospitality and with retail, that if there was certain suppliers trying to, I suppose, get their foot in the door, that they might be willing to hand over the brown envelope or the skiing holiday away. So just to be careful that you kind of, you stamp out that and put clear kind of rules in place. We also have deductions from wages. So it's just, in an event where perhaps you might have accidentally overpaid, or there may be kind of due to gross negligence damage done to the property and, repairs are needed. Or unauthorised use of credit cards, or indeed somebody dipping into the till when they shouldn't be, even with or without an IOU, that's where we have to kind of put, again, some sort of a policy there to stop us kind of from losing money because of it. Right to search. Again, this is a big one. We would get a lot, I suppose, in every occupation, unfortunately, but it kind of can be very, I suppose, in the industry I know even from hair salons down to obviously yourself in pharmacies, where employees have access to to certain things in the company which they wouldn't normally have access to, where you'd be able to go out and kind of buy it in any shop. And again, there could be times where, because I suppose in the nature of certain individuals, this could be quite lucrative for them, where they would kind of sell it on or use it for their own benefit. So it is important to have a right to search, because I know we dealt only not too long ago, a couple of months ago, just with a lady, and she knew herself from the storeroom that there were certain key items of stock that was going missing. That was very, very hard to get. In fact, I think she was bringing it over from Europe somewhere. And it turns out anyway that it was a certain employee on a certain day during the week when they were in, that was kind of, one by one trying to take as much as they could out of the company. But they were found and caught, and thankfully they had good procedures in place to do it, and they had a very good CCTV policy as well included, that they could use all of this in the disciplinary meetings. And at one stage I know they nearly went to prosecute, but that's just the importance of all of these. It's all fine and well kind of, having a company and saying it's my company, I kind of do what I want when I want, but the reality is very different, and it's very, very different, especially when you come into a labour court and have to sit in front of a judge, or indeed even with the adjudicators now, that you need to have very good sound reason and rhyme for doing what you're doing and decisions that you take. We've just built in here with a Sunday premium as well. Again, that the time plus a half and time plus 1/3 is gone, but you still have to pay, you know, a certain premium. And we have, in this case, kind of built it into the rate of pay that it's already factored in, so no further payment is due. We have a layoff on the short time side of it as well. Again, you can go on to to view the sample documentation, and what you'll need from that angle will be just your license key. I'll just copy it there. And then once we enter that into this, you get a wealth of documentation that's online that is also included with Bright Contracts. So you'll see, again, there's far more there. I know Laura spoke earlier about the restrictive covenants. Then we've casual contracts content, layoff, short time, mediation, right to search, meal allowance, 0 hours contracts, Sunday premium, car allowance, so on and so forth. There's quite a bit there. And then we have loads of HR guidance as well for employers, and additional HR documents that you can use. Now, as well as what we have online, we have loads, obviously, in-house as well. So if there's anything that's missing there that you feel that you need, or you need assistance in drawing or drafting up letters, again, the support team give you full assistance and support with that. So that's really all the online side of it. And then we'll just go back, and if I went up into Bernie's contract, I'm sorry, now, and we can just preview it. So we see Bernie's contract is 6 pages long. And again, as I said, all the background information kind of stays within the software. And just when you enter in the key and go alongside a series of questions, there's your contract created. And all you do is print off 2 copies, sign and date it, obviously on behalf of the employer. And you will give it to your employee, and you will just ask for them to sign and date and give 1 copy back. And you'll keep that on file. And that's really how simple it is from that end. The handbook, again, I know Laura spoke about earlier on, I'm just conscious of time here as well. It's just made up. If you were to do absolutely nothing with the handbook at the moment, you have a 37, 38 page, and it's literally ready to go for your own company. And you'll see as well, like all the additional content that was added into it through the customization with IPU and Bright Contracts kind of leaves it just fully ready made for your pharmacy. And it includes all the specific areas that it's very important to outline, such as the likes of, if you're saying from, you know, even the retail side of it, if employees are going to purchase anything in the company, that there's, again, a procedure on how this is followed. If they're dealing with customers in the pharmacy, again, you know, the set policy you have. If they come into contact or believe that there might be somebody that's shoplifting, again, a policy that they need to adhere and follow. And the employee's personal belongings. It's just, like, there's just a lot of procedures in here. And again, as Laura mentioned earlier on, a lot of it is all tailored, you see, throughout all the mention of the pharmacy. And again, it's all relating and applicable to your own specific business. So it's very, very, I suppose it's nice, and it's a great thing to have the tailored handbook ready to go. And we don't put anything extra. There's never anything additional inside of the company policies and procedures, and that's set out and ruled by the Labour Court recommendations. So if something does go wrong inside, that we have the proper process that we follow, and that equally your employees know what they need to do and who they need to speak to in any given stage throughout each process. So you have your bullying harassment, you had your grievance disciplinary, your health and safety policies. Again, it's not a company safety statement, but we cover many of the key areas here that we need to ensure of. And I know from a retail point of view as well, like the customer and employee safety side of it, and if there's customer accidents, that there's a process that they follow on how to file it and who to notify to as well. Then you're going into your quality policies and ensuring that, you know, nobody is discriminating under any of the 9 grounds, and then down into all your terms and conditions. So these are just where we kept our contract nice and short and sweet. We're able to elaborate further in this section here, and it covers loads to do with the hygiene, absence, sick leave, dress codes, alcohol and drugs. So again, outlining fully, even from your end in the pharmacy, of what exactly is required and needed. And then we have obviously our full section here with working in the pharmacy. And then we've an outline, an overview of all of the leave and benefits down into our pension scheme, and then with study leave. So we do cover absolutely all angles. So that's what literally sits inside the software, and there are our main areas. So again, just our summary and our overview, and once we start signing in, the people have received their employee contract, that'll all change for us as well, and it'll tag and track fixed term contracts for us, so it'll let us know when that's coming to an end, if there's 30 days, so it just lets you deal with it, and you're able to password protect everything in the company also. We have a full getting started guide for all IPU members, so when you do download and purchase your license key, right from the start you'll have all of the assistance that you need and how to set it all up. But as I said, there's a full team inside that's waiting for your call anyway, so we'll give you as much support and help that you need, and that'll be throughout the year as well. Okay, that brings me to a close. I'll let you go back to Laura now. If there's any questions, we'd be very happy to take them.
Great, thanks very much, Michelle. Just while we're waiting for the questions, I suppose, to come through and come in, I hope you found that useful. And I really believe that the IPU tailored version, it really is kind of it's so powerful in terms for yourself to minimise your time that you're spending on HR issues. It gives you the peace of mind that you're using policies and procedures that have been recommended or supported and approved by the IPU. And it's really, from a user point of view, there's really limited HR knowledge required, because Bright Contracts does everything for you. We keep it up to date as employment law changes, as it does all the time. So we'll just send you an update, meaning, again, the worry that you have to take on is totally, I suppose, minimised. So just, I suppose, looking at a few of the questions that have come on, when I issue my contract of employment, what happens if an employee refuses to sign the contract? This is a question we get quite a lot, and definitely it's a valid question. I suppose the answer I would give is the legislation and the onus is always on the employer to give and issue the contract of employment. The employee does not have to sign the contract. Obviously, it's best practice and it's the result that you want is to have the employee to sign it. In my experience, when I've issued contracts of employment and gone through processes, I generally have always reached agreement. But what's really important is, I suppose, the process of getting there. If there is one particular difficult employee you're maybe having issues with, so it's very important to have a process and to have a communication process, and let it be open and transparent and honest, because I see it as a benefit for putting out contracts of employment, because you're, as much for you're protecting yourself, you're ensuring that the employee everything is above board, and you're showing that you are an honest, reliable employer. But it's very much about being open and honest and giving documentation to an employee, and keeping records of that, being open to be able to take their questions, always answering their questions, and being approachable for them. And I suppose the main thing is just to keep a record then that you can show that you've gone through a process, you've been there to answer questions, and just make a note then that they've refused to sign it. I suppose as well, by virtue of the fact that you have an employee coming into work and completing their tasks and answering to their manager and accepting their pay at the end of the week as well, is also by virtue of the fact of all of that they are in agreement somewhat as well. So that's kind of protecting you. So I suppose the onus is on you as an employer to get it out. There isn't legislation to say that the employee has to sign it, but best practice is that you would go through the process, I suppose.
Absolutely. We have a question there that if a shop has a student for work placement or a transition year student for a few days, is a contract necessary? I suppose the short answer to that is no, because really you don't, or the legislation would say that if you have somebody working for less than 1 month in the company, it's not necessary to have a contract in place. And that's not to say if somebody joins the company and you give out your contract and your handbook and, as a job description, whatever else you need to give, there's not a problem. But for somebody that's just going to join you, you'll normally be kind of filling in or completing certain forms from a college or a school that'll be setting out the type and job description that they'll be doing with you. And the fact that it's only kind of work experience and they're there to gather as much knowledge and information and give them some sort of practice, I suppose, in a working environment, that's no, it wouldn't be necessary for a couple of days, absolutely not. But you'd ensure, obviously, that everything was right in the company from, a health and safety point of view, and that they're included, on the rostering and stuff like that as well.
Yeah.
Okay.
Perfect. Just another one. What if we want to add in or make our own changes? Can you? Yeah, absolutely. That's a good question. We've made this content with the IPU in mind and with you as users in mind. But Bright Contracts is full. It offers full flexibility as well. You're not tied into the IPU contract or the IPU content. It's there as a kind of a guiding path for you or as guidance, but absolutely you have full flexibility to change it and add in whatever is applicable to your store and your employees. And what I'd say is that we're always at the end of the phone as well if you did want to make a specific change and you wanted to run it by us or just see what we think of it. We're happy to do that as well. So the content is there as an IPU guide, but you're fully able to make whatever changes you want to as well.
Sorry, I probably should have showed that a little bit earlier on in the demo, that there is an area within the software, exactly as Laura said, that you can delete the sections out of it or contents out of it. Now that doesn't mean it's gone anywhere. It just goes up into an optional kind of sections folder in the top of the screen that you can add again at a later stage. And then obviously you can include subsections. And so if there was maybe a new policy you wanted to introduce that's not currently in the handbook for Bright Contracts, we can help you prepare that as well, and then it's very easy just to add it in to your company handbook. But yeah, it's absolutely fully flexible from that point of view.
Yeah. Just one last question has come in, and probably not one for you, Michelle, if you don't mind. How much is the software?
Well, the software is $399 ex VAT, and that'll give you the software package plus the full support and all your online documentation as well for a full 12-month period. And what it'll also include would be the likes of today's webinars. We would carry out quite a lot of webinars monthly, and we go through all the key areas, let's say, that we get in kind of from the majority of employers that will be dealing with employees that are, out on long-term sick leave, how to discipline, how to have a proper disciplinary procedure in place and how to use it. We go through grievances, performance appraisals, performance management, timekeeping, just a lot of different things, and you'll have access to all the free webinars and also to seminars that we carry out throughout the country. You'll have access to come to them as well for free, and then all our documentation as well. And of course our dedicated employer advice line. Don't forget about that.
Absolutely.
We're here. It doesn't make a difference if you ring us 15 times a day or 50 times a year, unlimited you have. Absolutely. So sorry, yeah, $399. That's for one company. So that's a single company with, whether if you've 10 or 10,000 employees, it never goes any higher. And then we also have a bureau version that if you did have a couple of different companies, perhaps, one of your companies was a pharmacy and then you had a different, an equestrian centre and the corner shop, whatever it may be, we have a bureau version available as well at $599, and that lets you set up all of the companies, and then you'll have all full support for each one of them as well. Okay.
Perfect. I was just going to mention, just as on the back of what Michelle has just been saying there, obviously we've kind of, employment law is massive and we can't touch on everything in an hour, I suppose. So we've touched on the contracts and handbooks today, but we do hold regular webinars, and we have two planned coming up in April, one on how to handle employee theft in the workplace, which is on the 5th of April, and we have one on working hours and rest time and breaks, holidays, all that kind of working time piece of legislation. We'll be talking about that on the 19th of April. So they're just kind of 2 dates that if you're interested, do sign up on the website. So I think we've gone over time. Apologies.
As usual.
Yeah, I think I was to blame this time. Usually it's Michelle. But I hope you found it useful. Thank you very much for attending. If you do want to have any questions, or if you want to contact us directly, or if you'd like a demo, just one-on-one demo, we'd be happy to help you out. So just do let us know. I've left the contact details there. Obviously, I work closely with Susan McManus in the IPU, and if you want to go to Susan, she can give you some more information with regard to kind of the IPU angle on it, I suppose. So with that, I will close off. Thank you again very much, and I hope you found it useful.
It's great. Thank you very much. Bye-bye.